All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We're here in our case 1CA CV 17-0347, Barroso versus Barroso. Each side will have 20 minutes to present their argument. Appellant, you may reserve any time that you want for rebuttal, but you'll have to keep track of that yourself. We have a clock at the podium to help you keep track of your time. We are recording the argument. The argument will be on our YouTube channel in a couple of days, so you can see how you did. Because we're recording it, please identify your client and yourself so that we can keep everything straight. We've read the briefs and the record. We've conferenced the case. We're familiar with the argument. So when you begin the argument, just launch right in to what you would like for us to know. Counsel, you may begin.
Good morning. Steve Everts on behalf of the appellant and respondent in the lower court, Jorge Barroso. May it please the court, and this is my client, Mr. Barroso, who's present in the courtroom today. When I was a young lawyer, I did tort work for the first 15 years of my practice, and I learned from some very significant lawyers in Phoenix the importance of preparing and submitting findings of fact and conclusions of law. And I've continued that practice as I've done my 25 to 30 years of family law practice since then. The rules in family law require that findings of fact be specially found when a request is made. I followed my normal practice and requested that in the trial court in this particular case. Unfortunately, it's our opinion that the trial court did not specially find the facts that needed to be found in connection with this case. In fact, there were very few. They either are insufficient, totally lacking, or contrary to the evidence that was presented.
Just to be clear, though, you've raised very specific challenges to portions of the decree. The point you're making sounds like it could be an overarching call for a generalized remand for an entire new trial. That's not how I took your brief.
I didn't ask for an overall remand for a new trial, but I will say, in light of the number of issues, and you've obviously seen that by the amount in the brief, that we have claimed a number of findings of fact that are lacking in this particular case to support the rulings that were entered.
Sure.
Understood? The point is that if correct findings of fact are made, then not only does this court have the information that's necessary in order to review what the trial court did, but we have a way of knowing whether or not it was done and whether or not the evidence was properly reviewed. And if not properly reviewed, then the orders that are based upon those findings would be changed and altered accordingly. I decided today to prioritize the arguments because there's no way with the number of issues we have to cover this in 20 minutes, but I was going to cover them in the order which I think are the most important financially to the parties. Obviously, the children issues were already resolved by stipulation in the trial court. I'm going to begin with a discussion of RSUs. Restricted stock units are a specialized category of stock options. The reason why they're restricted is because they have certain requirements to them that normal stock options do not always have. In this particular case, Judge Whitehead ordered that the wife was to receive a reimbursement payment of over $130,000. In doing so, he entered no findings on the identification of the grants. He identified no values that were associated with any grants, and he provided no basis upon which to calculate or to find out why he did $130,000 in this particular case. So there's those three problems that I'm going to address. First is the character. Excuse me?
Isn't there a fourth potentially? Our review of the record showed that some evidence that certain of those units were sold during the marriage. Perhaps certain was a bad word. Some of them were sold, and it's very difficult to tell what remained in the estate at the time of trial.
Yes. Of the 3 points I was going to mention, it's the non-existence of those, meaning that they had been granted, vested, and exercised, and spent before they were ever a trial.
Was there evidence presented, though, that they had all been spent?
No.
Okay. So there's potentially some pool of them remaining.
If you remember, in the accounts that were listed, one of the disputes that was raised are the Chase accounts. It was husband's testimony that the balance in the Chase accounts, which was the roughly $60,000, was mostly funded by the sale of RSUs.
I understand, but when the trial court has a difficult job to do here in sorting all this out.
It does.
And looking at, for example, tax returns, there is some transactional activity reflected, but it doesn't appear to square with the total number of RSUs. Are you just suggesting that the trial court needs to roll up its sleeves and get back into that?
RSUs,
as opposed to telling us that we should find, as a matter of law, that there were no RSUs to divide.
I'm suggesting that the trial court should roll up its sleeves and get back into the RSUs. I think that's the proper answer that should have been done at the time of the trial, which was not done. Let me just briefly address, if I may, the characterization. Of course, it was father's position at the time of the trial that the RSUs were not community property but were sole and separate. It was based upon the vesting date. It was based on his testimony, which was uncontroverted at the time of the trial, that the RSUs did not vest until after the date of service in this particular case with regard to most of them. I will point out to the court that not only would Mother not be in a position because she doesn't have foundation to render any testimony in that, but she provided none, not only from herself, but she didn't hire any kind of an expert or other professional that would have come into the trial to suggest something contrary to what Father testified to. And Father's testimony was confirmed by the brochure from the employer, in this case Amazon, that those RSUs were provided for future services. As this court is aware under the Brebaugh case, which was issued back in 2005, those RSUs have to be characterized, and that's the first issue that the trial court has to do. Which ones are community? Or if they're not all community, what is the portion that is the sole and separate piece? As you know from reviewing the record here, the trial court did none of that, and that was required at the time. Second thing is the non-existence issue that was raised by the court. Most of the RSUs, if you remember, when he issued the order about the RSUs, he said they were anywhere from 2013 through 2015 when he issued the ruling, without identifying which, if any, of those were included. It was husband's testimony that the ones that had been issued prior to the date of service, which was in 2015, had already been cashed in and been placed in accounts and sold and used for community purposes. Obviously, you can't divide or reimburse somebody for assets that have already been gone. They have to be in existence on the date of the decree, and they weren't in this particular case. There was no contrary testimony offered by Mother with regard to the fact that those had not been sold and cashed in. These people lived in Florida, moved to Washington, moved to Arizona. He was transferred by employment. She moved. They had all kinds of expenses on credit cards. Even she admits, and the court found that she had a number of credit card debts at the time of the divorce. All of the RSUs that were being used during the marriage were used to fund those things and to pay for those expenses. You can't divide something that doesn't exist. If I might analogize to the court, if you have a house that is worth a certain value on the date of the divorce, well, let's suppose that the house is in existence and is sold prior to the date of the divorce. And the equity is then used from that sale to buy other things. You may purchase another home, you may use it to pay down debt, you may do a variety of other things with those funds. But if it doesn't exist on the date of the decree, or at least at the time of the trial, there's nothing to divide because the funds have already been used for the benefit of the spouse that's claiming that there should be some reimbursement. In this particular case, husband and wife had already been reimbursed one half of the value of all those, so they should not be there. I would point out to the court that in this particular case, the wife provided no evidence that husband had a girlfriend, he had a drug problem, he was a gambler. There's no waste information. There's no misspending of any kind that's designated during that period all the way from 2013 through 2015. All of that would have had to have been pleaded and proved if there was going to be any claim. I would remind the court, just last year in the Barroso case that came out, pre-petition payments of expenditures by a party for another party are not to be reimbursed. It's the post-petition payments that it would be reimbursed. In this particular case, there wasn't anything to be divided here.
The court didn't have a lot to work with, though, did it? I mean, to try and sort out these relatively complex financial issues just by he said, she said is a pretty thin guide for the family court.
I would.
There's not a lot of documentary support for any of these contentions.
I will wholeheartedly agree with the court that doing RSUs is one of the most complex calculations that one has to make when they're dividing community and separate property. But that's not an excuse for not following the law and doing it.
Well, my point wasn't exactly that this is complex. I'll admit that it is, but my point was that the evidence that was offered was skeletal at best.
There aren't any parties other than the two parties, yes, and so they're speaking with lay terminology. Husband did provide a complete list of the dates of the grants, the dates of the vesting, the dates of the exercising of all the RSUs, and our asset debt chart that was attached in both pretrial.
Surely some documents come when you exercise an RSU. That's not just a note you make on a sticky. There's got to be some documentation. There are tax consequences.
Yes. Well, some of it did show up on the tax returns. The 2009 through 15 tax returns were in evidence, and I would point out to the court that on the asset debt chart that we prepared and attached to the pretrial statement, in Exhibits 58 and Exhibits 59 were the references to which those RSUs were all based when we outlined every one of those. Based on the lack of an expert in this case, we outlined every piece of evidence that we could to identify that for the court. Okay? The third thing that I wanted to finish up on the fact that they were not in existence by reminding the court that there are lots of funds that are earned during a marriage that don't exist at the time. They don't just sit in an account to be divided or to be reimbursed as the trial court did here. It acted as though the RSUs were just kept in an account and just held there so that wife could be reimbursed. That's not what happened. They were sold. The tax returns, actually, that were in evidence show that they were cashed out to a certain degree. Some of them had ordinary income tax that were taken because husband was paid on a W-2 form, and the W-2 forms were in evidence, and the tax returns showed that there were capital gains. So if you held the RSUs long enough to satisfy the holding period, then you would pay capital gains on them. Those were also in evidence. Is it complicated? Yes. Does it need to be done? Yes. That's the only way you get a right answer in connection with this case. The third point is also a sophisticated one, but that's the tax-affecting impact of the RSUs. As I mentioned, husband had ordinary income taken out. They were showing right up in his W-2 forms. If you were going to give the wife half of them, you'd have to take into consideration the tax consequences that were done, because he would have paid all of it instead of only half of it, and he shouldn't have been paying the tax consequences on her share. That's the Roe case that we cited in the briefs. The court stated that the court should consider the tax consequences when it's doing this kind of a calculation, and we believe that in this case it was entirely justified. All right, second point that I want to bring up. I've covered RSUs unless you have any other questions. Spousal maintenance in this case. Wife was awarded $3,000 a month for 30 months. The briefs already contain an identification and description of the incomes of the parties. The incomes of the parties I'll spend just a minute on, but they apply not only to the spousal maintenance arguments in this case, but they apply to the child support, and they also apply to the attorney's fees. You have to look at the respective financial resources, and you have to look at the incomes of both parties. In this case, the trial court did not make any findings. Well, they made some findings, but they made insufficient findings with regard to the financial resources of the wife. If you accept the ruling as it's presently constituted, and I know this is complex, because if you change the ruling, then it changes everything all the way down the line in this particular case. That's why I started with the RSUs, because they seem to be the linchpin to what happens to the rest of the case. But in this case, the trial court made no mention in its findings of $184,000 of Washington House proceeds or $182,000 of other assets that wife was awarded. That's $366,000. That's a lot of money. The court made no mention of that with regard to the wife in this particular case. And they, in fact, made an incorrect finding when the court said that they found that mother did not receive significant marital property on page 4 of its ruling. That's directly not only unsupported, but false and contrary to the evidence that was produced. I would also point out to the court that
there's a relationship between the RSUs and everything else.
Yes, sir.
At one point, you may be arguing against yourself a little bit, right? I mean, my impression was that the real issue with the maintenance award was that it instantly put father in arrears, not that it was inherently an abuse of discretion.
It made a retroactive order back to October 1 of 2015, yes, sir. And as a result, he was instantaneously in arrears because the ruling didn't come out until February of 2017.
Right. And I can understand why that might be a concern that we should discuss. But the award itself is not calculated by any guidelines.
No.
So does even a fairly significant, does $50,000 one way or another on RSUs really matter for purposes of the spousal maintenance award?
$366,000 significantly matters, in my opinion, with regard to a spousal maintenance award.
So are you making a 319A or B argument?
Both. 319A requires the court to determine the wife has insufficient assets to pay, including the marital property apportioned, and subsections 5 and 9 of B also require that same calculation. So even the entitlement issues in this case would have considered the $366,000 if it had been done properly. But there were no, you notice there were no findings on entitlement other than the wrong one, which said that the wife didn't have enough marital property. Excuse me. And yes, there is some backpedaling with regard to the RSUs. If the court left the RSUs the way they are, then they have to be considered in spousal maintenance. If the court changes the order with regard to the RSUs, then it may not have to be considered to the extent of the $130,000 that was awarded. And I recognize this is like a flow chart that has no end in terms of the way in which it connects to one another, but it has to start with the RSUs because that was the most significant asset. The Chase accounts I want to comment on briefly because we believe the trial court improperly divided them because husband provided testimony that the funds that were used from the RSUs to fund the 2 Chase accounts, of which mother received $26,075 as an equalization payment, were already spent on community funds. Now, if the father provides testimony of that, mother does not controvert it, then the trial court's obligated to make at least some findings as to whether or not the funds were used for a community purpose, because you don't get reimbursed for those if not. Even if they were there on the data service, you still have to show that they weren't used for a community purpose or that the court denied father's testimony. None of that was done in this case, and there was no findings on any of that. Number 4, Dr. Mellon's fees. We conceded at the time that we wrote our brief and acknowledged that father testified the funds that were used for Dr. Mellon, payments of $42,000. That's a significant custody evaluation. It's probably the highest one I've ever had in a case. He paid, and he was ordered to do it. But the trial court also said they would review the orders. The same thing they said with regard to the Parenting Skills Program supervision fees. When the court says they're going to review and reallocate or at least consider other orders of the court, then they have a duty to make findings with regard to those items. In this case, they did not do it with regard to either. And even though we've agreed that Dr. Mellon's fees were paid with community RSUs and therefore they were equally divided, we can't tell in this case, and that's the whole problem, which of the RSUs the judge did when he did his equalization payment for the $130,000. I can go back and calculate everything from 2013 through 2015 and come up with a rough estimate, but I'm really just guessing because he didn't provide enough information, and that's why the facts are lacking. But it's our opinion that even if the Parenting Skills Program fees, which is my point number 5, of $32,900, they're arguably paid with father's sole and separate RSUs because they vested after date of service in August of 2016. August of 2016 they were sold, and as a result, mother should be paying all of them back, or 100% of them, not just half, because it was her need to have the supervision, not father's. So when the court reviewed it, they should have made findings with regard to that. I've got 3 minutes left. I'm going to touch on attorney's fees and then reserve the rest of my time. Attorney's fees in this particular case, there were no specific findings either as a result of our request or the requirements of 25-324 where the court did. They said there was a substantial disparity of financial resources, but I've already mentioned that they didn't even count the $366,000 that mother was awarded as reimbursement claims. Having not done that, the court either improperly, insufficiently, or incorrectly made that finding, and therefore it needs to be recalculated. I'll reserve the rest of my time.
Thank you, counsel. Counsel?
Good morning. Jim Mueller appearing for the petitioner appellee Omega Barroso, who asked me to apologize to the court. She's at home today with her twins. Husband's argument is essentially that the findings of fact by the trial court were insufficient, not detailed enough. But the real gist of his argument is that the court rejected his version of the facts, his arguments, and in the main, for the most part, accepted wife's testimony and wife's evidence at trial.
Well, that just says why he's the appellant, doesn't it?
I'm sorry?
That just explains why he's the appellant. I mean, of course he's dissatisfied with some of the court's rulings. That's not very unique. But would you say that the findings of fact in the case were sufficient?
I would say that every trial attorney, every appellate court can look at a decision and say, I wish the trial court would have placed more information, would have given me more details. But the issue is whether the court was clearly erroneous as far as its findings. And I think the evidence at trial... Excuse me.
I'm sorry. The clearly erroneous standard applies to determining that findings themselves are wrong. The question here is, where are the findings? What are we to say is clearly erroneous if we don't know what the court found?
Well, as to spousal maintenance, as an example, the court went through every factor of ARS 25319B.
I want to come back to spousal maintenance, but
Okay.
Let's start with the RSUs. What findings did the court make on those?
Well, that there was a community portion of $260,000 and that half of that needed to be divided. And as to that amount, both parties in their briefs knew exactly what the court was referring to. It's exhibit number, I believe it's 55, where the husband set forth the RSUs that were acquired during the marriage.
Well, I see evidence in the record that some of those RSUs had been sold during the marriage. I don't know how many, but some. Does that mean that the court's finding is clearly erroneous?
Well, I think that the burden was on husband here to... The facts of the case were that...
I didn't ask you who the burden was on.
Okay.
I asked you, is that finding clearly erroneous based on the conflict between the finding we have in the minute entry and the tax returns?
Well, I don't think the evidence shows clearly that those same ones that were listed by, that are in exhibit number 55, were the same ones that were sold at an earlier time.
Well, you may be right, but what did the court find on that issue?
Court found that there was a community interest in the RSUs and that they should be divided.
So how is that finding any different from announcing the result? There don't seem to be predicate findings that lead to a result. There just seems to be the bottom line, which is not really a finding of fact. It's more the result.
Well, it's for this court to determine that. I believe that, and what my belief is isn't really important.
Or
but
mine.
On the RSUs, husband took the position up until the day of trial that there were $260,000 worth of RSUs out. At trial, on the eve of trial for the first time, he said, oh no, those are all gone. I think it's quite obvious from the court's findings that he did not find husband credible on that issue or many of the other issues.
But isn't that what a finding is supposed to be? Where you say, I don't find husband credible on this issue, therefore I'm relying on this evidence to find this fact. We shouldn't have to tease that out by implication. Findings of fact are supposed to make that express.
I'm not going to concede the issue, but
Okay.
it would be better if the trial court had said, I find husband's testimony and his evidence not credible. But I think you can infer that from the ruling here, because he decided with wife on almost all of these issues.
Oh, okay. You mentioned spousal maintenance. Let me ask you the same question
Okay.
I asked your colleague, which is, how is it that a maintenance award is made retroactive so that a party is in substantial arrears the moment the order is issued?
Well, I think under the statute that the judge has that authority.
Could you point me to the language? Because I was confused by where that authority came from. When you say under the statute, does the statute say that?
I don't think it says that. I don't know. I don't have the statute memorized.
Does a case say that you can do that? Because I've never heard of this being done.
All right. I don't think it's an abuse of discretion for the judge to do that. And the fact is that...
So father could go to jail on day one because he's in arrears on these payments? That seems harsh.
Well, seems harsh, but it hasn't, it didn't happen, and the court, since that time, the parties entered into an order where husband is just simply paying his monthly amount.
What's the point of making it retroactive? I can well understand the court has discretion to say there's going to be maintenance of $3,000 a month for 30 months because there's a rehabilitative need. I get that. But I don't understand either the purpose or the authority for making it retroactive.
Well, the only thing I can say is I believe the court has that discretion.
But
and
what does it accomplish? I mean, how does that even implement it? Does that mean that husband's supposed to make an initial payment of 15 months of maintenance and then payments going forward?
the court didn't order any kind of lump sum payment. The court didn't order any kind of arrears of payment over and above the $3,000.
So how did you interpret it?
I interpreted that the husband would start paying spousal maintenance and pay spousal maintenance until the entire amount, the $3,000 at 30 months, was paid in full.
So he would just pay $3,000 for 30 months. You would have treated it essentially as a prospective order.
Yes, and that's
might
what's
be a very reasonable thing for you to do, but that's not what the order says. I mean, presumably then husband already has interest accrued on a judgment that didn't even exist at the time interest started accruing. That seems counterintuitive, doesn't it?
I would say that it's analogous to the child support statute that allows for retroactive application. And it could have been in part that due to the refusal by husband here to support or pay anything to wife during this 15 to 18 months that this procedure went on.
But you say it could be for that reason, but we don't know that.
That's true. The court did not explain why that it was making the spousal maintenance retroactive.
Did you ask for it to be retroactive?
I honestly don't remember what it was in our position was in the pretrial. We asked for spousal maintenance from day one of the case. We filed as a part of our temporary orders, and that hearing was in December of 2015. We asked for spousal maintenance and child support. It was denied to my client at that time. I do not recall in the joint pretrial statement whether we asked for retroactive application of the spousal maintenance.
The analogy to the child support statute is far from perfect because the child support statute actually says that you can apply it retroactively and tells you for how long you can apply it retroactively. This statute doesn't say that.
I understand that it's not a perfect analogy.
Okay.
All right. So, I do think the evidence, and we've talked about spousal maintenance, but I think the record supports what the trial court did, and that the trial court's findings were not clearly erroneous. As I indicated, the trial court went through the factors of AR Section 25319B and found as to each factor, and made findings as to each factor. Husband's argument appears to be, first of all, that the judge got it wrong, trial court got it wrong as to the income of both parties. but I think we set forth in our brief that there was plenty of evidence to support what the trial court found as far as the income of father and mother. Mother testified to the amount that the judge accepted. She also testified to some other amounts because these things are moving targets. This was trial over 2 half days, 2 months apart from each other. Her status, employment changed. It depends on how you look at her employment as far as the position that she was at versus being unemployed on the second day of trial. But she did testify to the amount of income that the judge found her to have. As far as father, we had 2013, 2014, 2015 W-2s, which showed significant income. In fact, in 2015, I believe his income was $338,000. So the amount of income was well within the court's discretion as far as both parties were concerned. Father or husband also argues that the court failed to consider that mother received significant marital property and was awarded significant debt. The facts, again, show that she was awarded significant debt. It was sole and separate debt. It was debt that was incurred after the date of service, but it was still significant debt that she incurred while she was not receiving any kind of support from father. And you'll remember, again, the facts of this case, that parties moved to Arizona. Within 3 weeks, they have an argument. Mother calls the police to come out because father's hiding her cell phone from her. The police come out, and during interviewing both parties, it turns out that mother had flicked father's nose. Scottsdale police take her off to jail. She spends the night in jail. While she's in jail, she's served with an order of protection. She is released the next day. She doesn't have proper clothing. She has no money. The order of protection gives father exclusive use of the family residence, so she has no home to go to. She has no phone. Fortunately, she meets a passerby who directs her to the public library at Scottsdale, downtown Scottsdale, so she can contact her family. That's how this case started. And so as a result, she did incur substantial debt, and maybe, not that I want to bring up the retroactivity of spousal maintenance again, but that may also be a factor that the court took into consideration in applying it as far as retroactive support. Husband argues that the house proceeds weren't taken into consideration. But again, the court did take into consideration, and he found that there were no significant marital property. That's a factual determination. Husband wants to argue $180,000. I'm not sure where he's coming up with the $360,000 figure, but that this is, substantial or significant assets that should have been taken into consideration. Well, the court made a factual determination, and $180,000 may very well be significant, or under some scenarios, or some. But the court ruled in this case that money that mother had received from the sale of the family residence was not significant. And I don't. Again, arguments made as to duration, that there was no basis for duration, but again, this is the court has given the trial court great discretion in determining the matters of spousal maintenance and child support. Mother was seeking 36 months. The court ordered 30 months. Father's position was no spousal maintenance. So there was no abuse of discretion in the court entering an order for 30 months of spousal maintenance. Child support issue, the complaints on the child support issue are that it was go to father's income again, and also go to equal parenting time and the dependency. Let me just quickly speak to that. I've already talked about the income of both parties and that there's is sufficient evidence to support the court's findings in both those, as to both those factors. The equal parenting time, the parties at the first day of trial in October of 2015, October 2016, reached a Rule 69 agreement where mother would start having more parenting time and eventually transition to an equal parenting time. The court made the child support order effective as of October 1st. I would point out that immediately mother started having additional parenting time. Equal parenting time, no, but additional parenting time. But again, the guidelines say essentially equal. It doesn't say perfectly or exactly equal. And as was testified to by the custody expert that husband hired and that was appointed by the court, there was never any reason for supervised parenting time. So I believe the evidence supports the court in making the child support award as of October 1st. As to the dependency, we said in our brief that the guidelines do provide in proportion to income. I'm not conceding that issue, but that's what the guidelines say. I would just simply point out that the guidelines are exactly that. They're the guidelines. In re Marriage of Pacific says they're a source of guidance, but I don't think it's an abuse of the court's discretion to, in this case,
they're a source of pretty specific guidance unless findings are made to support a deviation.
Well, again, I'm not going.
The guidelines are not sort of aspirational suggestions. There's a calculator that you use to calculate a specific amount.
Yes, but again, they're a source of guidance. They're not law themselves. They're not statute.
The guidelines
Yes.
aren't law?
Well, I'm looking at the Pacific.
25320 commits to the Supreme Court the responsibility of creating the guidelines. They're prescribed by the Supreme Court. I don't know how much more law you can get.
Well, all I'm looking at in re Marriage of Pacific, 168 Arizona at 463, and it says child support guidelines are not a source of law, but a source of guidance to the trial courts. And that's my only point. But
What's the year on that case?
I don't have the year in front of me, Your Honor.
Okay.
All right.
It's not very recent.
Okay.
Based on the volume number.
All right.
Okay.
All right. So, and again, as I said in our brief, I think if that's an area the court feels like the trial court abused, then it's easily corrected by just simply doing it in proportion to income. But I would point out that on this issue of the child support awards that, again, the trial court is giving a high amount of discretion and deference in coming up with these. Division of assets. One issue was the vehicle valuations. It wasn't even brought up today. I believe the court found what the values were. There was evidence of those valuations in the record, and that's no abuse of discretion and is certainly not clearly erroneous. The Chase bank accounts. The court found that there were balances in the two Chase accounts. Those balances needed to be equalized as of the date of service. I believe the burden was on father to prove that that shouldn't be done, and apparently he didn't achieve that. I've run out of time. I would just simply say that, as I indicated earlier, often we would like more detail, more findings of fact. I'm sure you see this all the time. But at the end of the day, I think the evidence supported what the trial court did here, and the rulings were fair and equitable, and I'm asking the court to affirm those rulings, and thank you.
Thank you, counsel. Rebuttal?
Thank you. I'll be brief. I want to clarify for the record, it's Exhibits 52, 53, and 54, which were the exhibits and evidence that talked about the RSUs in addition to the tax returns. I just looked at my notes. It's obvious from the review of the ruling that the findings are lacking by the trial court in this particular case. Mother was faced with a difficult proposition because she had to argue that somehow they were sufficient, but instead she decides to say that the court must have obviously just rejected everything that father said at the time of the trial. There's a difference between no findings and rejecting what father said. It doesn't mean she wins automatically just because the court rejects.
Let me ask you, though, what you're asking for, because if we agree with you that the findings are insufficient and remanded, can't the court just then enter a finding that said, yeah, I rejected everything father said, and then that's the end of it?
Well, you can't be that general. They can on various points where father testified, but they're going to also have to talk about the evidence that's otherwise what father testified about that might be discretionary.
Well, I guess what I'm getting at is, are you asking for a remand for further proceedings, or are you asking for a remand just so that the court can enter findings based on its notes of what's already happened?
Both. I'm asking for further proceedings, and I want the court to fix the findings that it didn't enter at the time. When findings of fact are requested, we're not supposed to infer or guess, as counsel suggests to this court. That's the whole reason for asking for findings. I want to comment on briefly the spousal maintenance question that the court asked a few minutes ago. This may be contrary to my client's own position, but I do believe there is authority in Arizona for retroactive spousal maintenance. It's either 319, 327, or it's the statute that talks about when service occurs, you can go back to the date of service on the party who got it. That does not mean, however, that the court doesn't have to make findings if it's going to do a retroactive order of spousal maintenance. And I will clarify for the record, there was no request for retroactive spousal maintenance in this case. There was a request for an amount and a duration, but it didn't suggest that it would start on October 1, 2015, as was ordered by the court in this particular case. So the findings for both the retroactivity and when it started are lacking again, and that just supports the argument we've already made. Last point I would...
Could the court have done that if it chose to make them retroactive?
This is not the first case where I've not only seen the court order retroactive spousal maintenance, but I personally have made it, and I've had it made against me in many cases where the court will order a retroactive order of spousal maintenance. So if appropriate findings are made, I guess the court could do it if it chose to do so. Just to sum up, the child support credit was 6 months premature in this case. This case and mother's parenting time was under the supervision of Dr. Weinstock. The dependency exemptions, if you read the old 25-320, it was should allocate according to incomes. After the McNutt case that came out in Arizona, the guidelines were modified to say shall, and so ever since then it's been mandatory.
Thank you, counsel. We appreciate your argument today. We'll take this matter under advisement and issue a decision in due course. If counsel for the next case are present, we're going to stay on the bench while the attorneys come forward. Thank you.